So Michael just asked, how long do you have to file a personal injury lawsuit? And we'll apply this to Mississippi.
Well, it depends on exactly, who you're suing exactly. But if it's just a private individual, it's 3 years. In Mississippi, the statute is 1 year if it's a governmental entity, a police officer, fire truck, anything like that hits you. Slip and falls, most premises cases as well are 3 years unless they happened at a state-run entity like UMC, then it would also be 1 year. But the general rule is 3 years unless it's a special, company that you're suing.
Yep. And the key is we would, if someone's in an accident, encourage you to reach out to, a law firm, preferably our law firm, sooner rather than later. Because there's a lot of evidence that we can gather, things with regard to, treatment, because you get it, I was in the wreck, I feel fine, you don't do anything, and then, a month later, 6 weeks later, you're still hurting, so you finally decide, I'm going to go get checked out now. Well, guess what? The insurance company's going to have red flags all over your file at that point and start saying, that's not related to the accident. We don't know what you've been doing for the last month or 6 weeks or so forth. So, like anything, it's really important, Michael, to reach out to a law firm quickly. And then he also asked medical malpractice. What's our med mal statute?
I believe it's 1 year.
I think it's 2.
Is it 2?
2 years, I think, is what you've got. But that's a whole another ball game. Yeah. Tort reform came in, and it is so challenging on a med mal case that you have to already have your expert before you can ever file suit with regard to those. We partner with a couple wonderful law firms on medical malpractice cases. So, we don't file them, but we work with firms who do that. And that's kind of the same thing. Bankruptcy attorneys, you don't use the word specialization a lot in law, but that's the area that they focus on. Just like typically a medical malpractice law firm, that is their niche that they are going to work on, because they are uber expensive and then very, very challenging. I mean, if they have 100 calls on somebody with a potential medical malpractice case, they're probably going to take maybe 2-3 tops of those cases, just because the way the law is written. It is really challenging from 20-plus years ago when tort reform kicked in and capped your non-economic damages at $500,000 on a medical malpractice case versus a car wreck case where they're $1 million non-economic cap. So it's definitely a different avenue.